that came out, and I can just picture it now because I've been covering trials for a long time. I know what some defense attorney and some expert is going to say inside that courtroom. They're going to say he was in distress before he was on the ground. He was saying he couldn't breathe before he was on the ground. He was thrashing. He was hitting his head. The cause of death had nothing to do with the knee on the neck. I know we're going to hear it. I know we're going to hear it. Let's see if my think tank agrees with me, if that's going to be the argument from one of the attorneys in one of these trials. With us tonight, Anna Yum, criminal defense attorney, former prosecutor. She's in San Diego, California. In Atlanta, Georgia, Randy Kessler, family law attorney and law professor. Also with us, DeWitt Lacy, civil rights attorney, former criminal defense attorney. Anna, let me start with you. Do you think some lawyer, along with his pathologist, is going to come into the courtroom and say George Floyd's death was not caused by the knee on the neck?
Absolutely, Vinny. You know that's going to come up. And a good defense attorney will have to bring that argument up to avoid any kind of ineffective assistance of counsel claim. I think that that's going to be a huge issue, especially after reading some of the transcripts and the body-worn camera footage. I mean, if you think about it, especially when you think about Officer Lane's situation, when I read that motion to dismiss, I don't think that he's going to win that motion, Vinny, because probable cause is such a low burden. But I also think it's going to be difficult for a prosecutor to secure a conviction against Officer Lane based upon what we know right now, because I really believe that there's a difference as to what Officer Lane should have done morally in the court of public opinion versus what he can be held criminally liable for in a court of law. I mean, the prosecutor in this case is going to have to prove that Officer Lane played an intentional role in aiding and abetting Chauvin. And in order to do that, they're going to have to show that he knew that what Chauvin was doing when he was kneeling on George Floyd's neck was criminal. And if he knew that, he was intentionally aiding him, meaning advising him, conspiring with him, and encouraging this action. And so I think that intent is going to be one of the crucial things that the defense attorneys are going to have to argue, especially when you think about Lane saying that he told Chauvin, put him over to his side 2 times, and he only had 4 days under his belt, and that he administered CPR in the ambulance right after George Floyd was taken in. So what I think is that the defense is going to have a lot to work with if this case goes to a trial.
All right. DeWitt Lacy, let me put up on the screen what Anna was talking about, which is the law in Minnesota. To be criminally liable for the crimes of another, the state must prove, let's put that up on the screen, there we go, that the defendant knew his alleged accomplice was going to commit a crime, and the defendant intended his presence or actions to further the commission of that crime. We're not talking about Chauvin here. We're talking about Thomas Lane, who is controlling the legs, the one who asked twice to roll him on his side. DeWitt, do prosecutors have an uphill battle in convicting Thomas Lane?
It is certainly, Penny, to answer your question, it's certainly going to be more difficult than convicting Chauvin. Okay. But the problem that Thomas Lane runs into is that he does have training about positional asphyxia. He does have training about having somebody lying prone with weight on their back, let alone their neck. He does understand there's a significant risk to this man's health and maybe even his life, which is the reason why he gave some warning and indication to Chauvin that, hey, maybe we need to turn him over, because he understood there was a very significant risk to either great bodily injury or death of George Floyd. And yet, because Chauvin said, no, we're going to sit right here, he says, well, okay, I guess I'm clear and free of any type of liability or wrongdoing. And I don't believe that's going to go over too well with the jury. I think there are definitely some troubles that a prosecution has because he is a younger officer, and he at least acknowledged that there was some risk of harm. However, you don't get to just disregard those risks and say, well, somebody told me that we should just ignore this. I've seen this movie before, Vinny. I think it's called A Few Good Men.